Okay, I'm just going to begin. No clap, no clap, no clap, no need. Thank you, it's fine. Let's just start. We can save the claps to the end. Thank you very much for the introduction, Joseph. Thank you also to Christine von Hodenberg for being here as a representative of the German Historical Institute, as a co-host for this event. It means a great deal for me to have an invitation to speak about this topic at the Leo Institute for the study of the history of German-speaking Jewry, and to speak about it in this research in a city where I really got into the topic for the first time through kind of getting to know other individuals who are affected by some of the problems I'm going to be talking about today, and going through the experience of applying for naturalization and the difficulties related to that with them. So the beginning of my talk, I would like to take everyone back to a point in time which they probably remember, maybe wish that they didn't, to June 2016, and to a particular political event from that month, in which, if the slide were here, you would see a particular referendum result, 51.9% in favor of Brexit. See, there we go. We don't even need the slides. So we are living in the wake of that event. We are living in the context of the developments foreseen and foretold in relation to it, economic downturn, the waning of Britain's importance on the globe. These are all things that were predicted and foreseen before the referendum actually took place. There was, however, another consequence of that referendum, which was not immediately foreseen. And that was a surge in the number of descendants of German Jewish refugees who had come to England in the course of the 1930s and thereafter, who were applying for naturalization as German citizens. And there would be a slide here showing you headlines from English, German, and international news agencies reporting on this development, and also a useful graph showing you that there was an increase in the number of naturalization applications through this provision from the UK of 45 in 2015, jumping up to 1,647 2 years later. Before this presentation, I used my phone to look up what that percentage increase is, and it's 3,400%. Sounds very impressive. Probably doesn't mean that much when your beginning number is 45, but I wanted to use it anyway just for emphasis. What was the response of the German state to this unexpected and magnanimous, surge in interest for German citizenship, the legal confirmation of a connection with the contemporary German state? Another thing which I'm going to have to read off you from this printout of a slide, but you're not missing out on much. It's just a typed up quote from another document. The response of that arm of the German state, which is most closely connected with the individuals who are going through this process, the German Embassy from London, which wrote in October 2017 to the central office of the Auswärtiges Amt, quote, "Since the British Brexit referendum in June 2016, there has been a surge in the number of applications for renaturalization from former German citizens and their children. This is an expression of trust in our country that cannot be appreciated enough. Every application for naturalization by British Jews is the result of a personal engagement with a painful past. The trust in Germany that is expressed in such an application is the greatest compliment that those affected can offer us after decades of German efforts towards reconciliation." Thank you. Now, this is, I think, an emotionally empathetic account of the emotionally difficult predicament which many descendants of German Jewish refugees found themselves when they undertook the project of considering whether to apply for naturalization as German citizens, and to make use of a right to naturalization which was granted to refugees and their descendants by the German Constitution. And what was this right to naturalization, if not a hand outstretched, an invitation, a gesture promising a welcome return to their ancestors' former homeland, offered in the spirit of reconciliation, which, as the report from the London Embassy said, the German state had been laboring towards for decades. But this report was not only a message of celebration. There was a danger awaiting. And the report goes on, I quote, There is a problem in what is perceived as the arbitrary exclusion of applicants who were born in wedlock before the 1st of April to a foreign father and a denaturalized mother, given that such applicants are denied a right to naturalization. It seems arbitrary when siblings in one and the same family are affected by a similar legacy of persecution, and a right to naturalization is granted to some siblings but denied to others. This arbitrary differentiation between descendants, the offering of a right to naturalization to some and the denial of that right to naturalization to others on grounds that seemed immaterial to what these descendants viewed as the grounds for the offer of naturalization in the first place, repair for an injury which had been done to their parents, their grandparents, an injury which consisted in attempted persecution, potential attempted murder of those individuals. Why was now the German state differentiating on the basis of whether their parents had been married at the time they were born, whether it was their mother who'd been expatriated instead of their father? This was something which the German embassy noted threatened to endanger that project of reconciliation towards which the German state had been working for so many decades. The German embassy ended its report with a series of recommendations. It recommended to the German authorities in Berlin that they explore the possibility of legislative change, and until they could change the law, explore sub-legal possibilities for granting eased access to German citizenship for those individuals affected. I'm sure that many in this room know this was a report sent in October 2017. The authorities in Berlin did not heed those recommendations in the time immediately thereafter, such that in 2019, there was a flurry of negative reporting. Again, a beautiful slide awaits you when this finally is sorted out, showing a selection of headlines from the British, German, and international press relating to the fight of various groups of descendants to gain German citizenship through naturalization. It took a while for those problems to be solved, but solved they were, as the result of several other developments, one being a judgment in May 2020, goodbye. Someone had to leave early, he's not offended. A judgment in May 2020 from the Federal Constitutional Court, which ruled that the discriminatory treatment of certain descendants on the basis of the gender of their ancestor, whether the ancestors were married or unmarried at the time of the child's birth, and the point in time at which they were born, to be unconstitutional. But that did not eliminate all of the exclusionary grounds. It was still necessary a year later for the German legislator to pass a law which would extend naturalization rights to groups who had suffered Nazi persecution, who had never been granted rights to naturalization in the history of the Federal Republic, and also extending that right to naturalization to their descendants. This was done in a law called the Fourth Law for the Alteration of the Nationality Act, which was passed in August 2021. Now, one might ask the question, if the Federal Republic of Germany had indeed been working towards reconciliation with the descendants of victims of Nazi persecution and with the victims of Nazi persecution themselves for decades, why was it necessary that this change be made in 2021, 72 years after the Federal Republic of Germany had been founded? That is a question which my presentation is going to provide an answer to by showing how exclusionary regulations that were replaced in 2021 were created in the 1950s by West German officials, and demonstrating the immediate and the long-term effects of those exclusionary regulations that were created in those earlier decades. All right, so telling you what this paper is going to do, I was also going to tell you why this is significant for the historiography. Maybe that's not that important when we're this far ahead, but I'll just say it very, very quickly. There is a general assumption in the scholarship on post-war West Germany that the state has always fostered, welcomed, and supported Jewish return migration to the country, Jewish presence in the country, and Jewish belonging to the country. This scholarship has not assumed that this has always been motivated by kind of idealistic reasons or something selfless desire to actually repair harm that was done. Instead, there has been a kind of recognition of the fact that in early West Germany, Jewish presence was valued for what it could do for West Germany's reintegration into the community of nations, for demonstrating that Germany had learned lessons from its past and that it understood that having a flourishing Jewish community in the country was a precondition for re-entering this community of democratic nations. The material that we're going to look at today tells a rather different story. It shows how West German state officials tried to limit Jewish return migration to the country, tried to limit the conditions under which Jews, including Jewish former German citizens, could regain German citizenship. So it's kind of adding, I think, a rather interesting critical qualification to that existing scholarly assumption. Another thing which this material does, it provides some new material for existing scholarly inquiry into the politics and practice of Wiedergutmachung, of reparative justice in the wake of the Holocaust. And it also, maybe this is not the most interesting for the people here in person, maybe some people on the internet are a little bit more interested in this aspect. It's an interesting addendum to a field of research which has emerged in the last 15 years called Behördenforschung, research into ministries, authorities. This is a form of research which has been pushed on a lot by kind of large-scale, multi-person research projects that look at continuities between the Nazi era and the post-war era, both in terms of personnel and policies in many of the central ministries of the Federal Republic. So just to give you an idea of those things that are going on there, now we can actually jump into the meat of the presentation. Naturalization rights of German Jews and their descendants in the Federal Republic of Germany. Who are we talking about when we are talking about German Jews? So most obviously, we are talking about the individuals who possessed German citizenship, who were of Jewish faith or of Jewish ancestry, of which there were 400,000 living in Germany, according to the June 1933 census. We aren't only talking about the German citizens, the German citizens of Jewish ancestry and faith who live in the country at this time. There were also 100,000 Jewish residents of the German state in 1933 who did not have German citizenship, who were either of foreign nationality or who were stateless. This did not mean that they were recent arrivals in the country. Around 40,000 of these 100,000 foreign or stateless Jews have been born in Germany. And this already kind of draws our attention to the fact that, well, one, Germany did not have jus soli in its nationality law until 2000, which means being born on German territory did not automatically confer German citizenship. And also, German naturalization practice in the imperial and Weimar periods was highly anti-Semitic, especially in relation to Jews from Eastern Europe. Normally, their naturalization would only be even considered after they lived in Germany for at least 15 years, if not a generation. So these are individuals who do not have German citizenship, but in many cases were born in Germany, had lived their entire lives in Germany, attended German schools, spoke German, identified as German, were German in everything but their legal status. So these are two groups that we should keep in mind when we think about German Jews and their relationship with the German state in this post-war period. But it doesn't end there. We also have to keep in mind the fact that there were also German-speaking communities, German minorities, outside of the boundaries of the German state. So this is a map which shows you the red dots, all of the German-speaking minorities in Central and Eastern Europe, a map from 1931. And there were also kind of large German-speaking Jewish denominations within these German minorities. So to just give two famous examples, Franz Kafka was a member of the German-speaking Jewish community in Prague, in Czechoslovakia, and Paul Celan, a member of the German-speaking Jewish minority from the Bukowina, specifically from the kind of Jewish German intellectual and artistic Hochburg of Czernowitz. Now, what forms of citizenship-related discrimination did these various groups of German Jews suffer during the Second World War or under Nazi rule? The first affected the stateless and foreign Jews who lived in the territory of the German Reich, insofar as Nazi Germany, almost immediately after the seizure of power, introduced formalized racial requirements for naturalization. Anyone who was living in Germany who wanted to become a German citizen had to prove that they were of Aryan descent through something like what you... Oh, wait, it's jumped. Huh? I think some of the slides have been deleted from the presentation. Okay. All right. Well, believe me, 1933, they introduced formal requirements that you had to prove you're an Aryan citizen. What you should have seen would have been an Ahnentafel, which was a document with which individuals had to trace back their heritage several generations to prove that their ancestors were of Aryan descent. And if they could not do this, they would have to send in photographs of themselves so that those could be subjected to racial examination. And that was a formalized requirement for naturalization from 1933 onwards. Another form of citizenship-related discrimination, which followed that early introduction of the formalized requirement of Aryan descent, was a law that was passed in July 1933. This was the law on the revocation of naturalizations and the stripping of citizenship, a law which consisted of two parts. The first part allowed for naturalizations that had been performed between 1918 and 1933 to be revoked. This was immediately used intensively against Eastern European Jews, affecting around 21 to 28,000 Eastern European Jews who had been naturalized during the Weimar period. The second section of this law was a law about the punitive expatriation, the punitive stripping of German citizenship from individuals who had already left Germany and who were deemed to act against their duty of loyalty towards Volk und Reich. This was initially used against high-profile political opponents of the regime, and from 1937 onwards was used ever more increasingly against German Jews who had managed to leave Germany into safe emigration in other countries. One of the reasons this was used so much against those Jews who had already fled was the stripping of citizenship from those individuals allowed the German state to seize all of their property and assets which remained in the Reich. Now, this was still a procedure which took up a lot of administrative labor. And after the beginning of the Second World War, administrative expertise was needed elsewhere. But there still was a need to strip citizenship from German Jews and to seize their property. So in November 1941, a decree was issued which saved the German state that administrative work. The 11th Verordnung zum Reichsbürgergesetz, the 11th decree on the Reich citizenship law, which decreed that any full Jews who were outside of German territory could not be German citizens, which meant any individuals who had German citizenship who were classified as full Jews according to Nuremberg racial laws automatically lost their citizenship the moment they stepped outside of the territory of the German state. This affected all of those who had already made it into exile in the West or elsewhere in the world, and it also affected all of those who were deported to concentration camps or ghettos in the East. This also saw that their property and assets would fall automatically into the ownership of the German state upon leaving that territory. So it's also bound up very, very intimately with the expropriation of German Jewry as part of the Holocaust. Now we get to this slide, after the few slides which are missing, which tells you about the discrimination which was visited upon the Jewish members of the German minorities of Central and Eastern Europe. During the Second World War, Germany performed mass naturalizations upon the ethnic German populations of the territories that it annexed and occupied, using their Deutsche Volkszugehörigkeit, their German ethnicity, as the grounds upon which they made these individuals into German citizens. In certain territories which were not annexed or occupied, the population was not mass naturalized, but was instead resettled, naturalized on an individual basis following a eugenic and racial exam. Jews, you might guess, were excluded from both mass naturalizations and the possibility of resettlement through the legal definition of German ethnicity, which was provided in 1939, which deemed that individuals of foreign blood, especially Jews, can never be German, ethnic Germans, can never be Deutsche Volkszugehörige, even if they have referred to themselves as such until now. So to summarize, which different groups suffered detriment in the area of citizenship law under Nazi rule? Those Jewish German citizens who had their citizenship formally removed by the Nazi state. And there's also a slide missing, which I completely forgot. So you're going to have to, sorry, I can't jump over this. It's a slightly important one. The Jewish German citizens who had their citizenship removed, the 11th Verordnung der Reichsbürgergesetz, through the two sections of that other law which I mentioned, you might have noticed it would be kind of random, the point in time at which the German state removes that citizenship. In November 1941, it hits everyone. Before that, it could happen shortly after you leave Germany. It could happen years after you leave Germany. It could never happen at all. There are things that happen in life in that intervening period which could still lead to the loss of your German citizenship. According to the normal loss provisions of the Nationality Act, this could happen if you acquire a foreign citizenship abroad upon application. If you're a woman, there's more chances that this might happen. If you marry a foreign man, bad luck, your German citizenship is automatically lost. The third variation, a little bit harder to stumble into randomly, applying for release from German citizenship. So that is something we also have to keep in mind. German Jewish citizens who fled the country could have their citizenship removed by the Nazi state, or they can end up losing it before the Nazi state gets round to stripping it from them. So back to the slide. We have to think about the Jewish German citizens who lost their citizenship in various ways. The stateless and foreign Jews who had lived in Germany for a long time, but who were blocked from naturalization after 1933. And the Jewish members of the German-speaking minorities who had been excluded from mass naturalizations on the grounds of their race. So these are the three different groups that we can think of as having suffered citizenship-related detriments during Nazi rule. Did any of them want redress? As a rule, no, and for understandable reasons. Many Jews did not want very much to do with Germany after 1945. And this is especially true for those who had their citizenship removed and were now living in other countries. Many of them did not want to see that citizenship automatically revived. It would have brought big legal problems for them in their new countries of residence, and it also would have brought with it emotional difficulties, forcing them into a bond with a country which had, until just recently, tried to exterminate them and everyone like them, from the European continent. This was something which had to be kept in mind by the Parliamentary Council, the body which was responsible for drafting what would become the Constitution of the West German state, which came into force in May 1949. The Parliamentary Council began their work in 1948. And while they did not spend a great deal of time talking about the issue of forced denaturalizations of former German citizens, it is something which concerned them for a while. And there were three main considerations that they were thinking about when they were talking about this issue. One was the aforementioned question of not forcing the citizenship upon people who did not want to have it anymore. They could not create an automatic regulation which would impose that citizenship on those who want nothing more to do with Germany. Two, and this is a rather interesting and surprising fact, the members of the Parliamentary Council are very, very explicit in the discussions of this, that they do not want to force any individuals who've had their citizenship removed to give up any new nationalities or citizenships which they had acquired in the intervening period. So there is a very, very explicit affirmation that Germany should allow these individuals to have dual nationality. And third, okay, security. Oh, sorry, there's something popping up on here. Yeah, sorry, there's something now on here which is stopping me from clicking. No, okay, great. All right, perfect. They also decide to include descendants. So I'm not going to read this to you because we're quite far along, but this is the article which has ended up being created. It says that individuals stripped of their citizenship for political, racial, or religious reasons in the Nazi period are to be renaturalized upon application, as are their descendants. What kind of legal provision is this? This is something that we in German call an Anspruchseinbürgerung, a right to naturalization. This means individuals who fulfill the requirements named in the provision have a legal right to the awarding of German citizenship upon application. This is different from how naturalizations normally function in Germany at this time. Most naturalizations at this time are Ermessenseinbürgerungen, discretionary naturalizations, where the state authorities have broad decision-making powers, they have broad discretionary leeway, and they will normally only naturalize if they determine the naturalization to be in the interest of the state. Why is that important? To show you why that is important, I want to show you the response of a local government official to the renaturalization application of a German Jew who did have a right through Article 116, paragraph 2 of the Basic Law. So this part of the Constitution which grants the right to renaturalization. And this is a response to an application from a man who was born in Germany in 1889, remained living in Germany until 1939, when he was able to emigrate to Shanghai. After he got to Shanghai, he was able to move to mandatory Palestine and was living there when the State of Israel was founded, so that he also automatically acquired Israeli citizenship. He decided, however, in 1952 that he wanted to return to the country of his birth to spend the final years of his life in a kind of setting and in a culture and around a language that was familiar to him. So he applied for renaturalization. Now, because he had a right through Article 116, paragraph 2, all the authorities really needed to do was establish that he had possessed German citizenship in the past and that he had been Jewish and therefore been subject to Nazi persecution on racial grounds. The local official who received this application, however, did not understand yet the difference between this provision and the ordinary discretionary naturalization provision, where the authorities would be able to raise objections of various kinds. We can see the kind of objection which is raised. I could not determine if R, so the name of the applicant, has any assets here. R is now 71 years old. He has no relatives in Hanau who could take care of him and would potentially need to be placed in an old person's home. It is unclear how he wishes to financially support himself, so that he would likely, support himself. His current homeland receives reparation payments from the Federal Republic, so that he would likely have a secure existence in Palestine, whereas here he might become dependent upon public welfare. I cannot support his application. So I think this is a statement which speaks for itself. You don't need me to gloss it. It's enough for us to just say this statement from this official had no consequence for the applicant because he enjoyed the right to naturalization granted by the Constitution. I want to now show you an example from an individual who did not have that right and what the consequences were for him. That individual is a man who was born in Leipzig in 1925 as the son of a stateless Jewish mother and father, so that he also was stateless. He left the country along with his parents in 1934. They fled to France, and after the Nazis occupied France, they went into hiding in the south of the country. One of the applicant's brothers was caught by the German authorities, deported to Auschwitz and murdered, but the rest of the family members were able to survive. After the end of the war, the rest of the family went back to Germany quite quickly, to Frankfurt am Main. The applicant in question here followed shortly thereafter, but he entered Germany without legal permission to migrate. And he was living initially in Frankfurt am Main without registering with the local police. A few years later, he places an application for renaturalization through Article 116, paragraph 2. And it takes a while before the authorities figure out that he had not actually possessed German citizenship previously, which meant he had never had his citizenship removed. He didn't enjoy the constitutional right to renaturalization. And this is the response of the state authority once this is realized. The above named who has applied for renaturalization through Article 116, paragraph 2, is living illegally in Frankfurt am Main without registering with the police. We are adding him to our wanted list to establish his current location. As soon as he is found, we intend to deport him as a burdensome foreigner. We do not support his naturalization, and there is no room for renaturalization as he has never possessed German citizenship. So an example of the not so warm welcome which awaited some of the German Jews who decided to return to the country of their origin and their youth, when they did not enjoy the legal protection offered by the constitutional right to naturalization. What were some of the other problems which some of the groups that I'd mentioned before were facing in the early 1950s? Be very quick with this. So the former German citizens who had lost their citizenship through the ordinary loss provisions of the Nationality Act before the Nazis had got around to taking their citizenship away, there was very, very quickly an established line that these people should not be granted a naturalization right through the Constitution. Some states went even further and said that those individuals whose citizenship had been removed by the Nazis, who had naturalized elsewhere after 1949, should also be denied a right to naturalization. As for the Jewish members of the German ethnic minorities in Central and Eastern Europe, No one recognized them as having become German citizens, and there are reports that these individuals were also being denied permission to enter the country, let alone naturalize as German citizens in the early 1950s. What part of the German government would have been responsible for providing a solution to these problems if we did actually perceive them to be problems? That would have been the Federal Ministry of the Interior, the Bundesministerium des Innern, or as I will be referring to it in an abbreviation, the BME. So I'm not talking randomly about body mass index at this point in the presentation. It means this building you see here. So this ministry was one of the authorities which has been subject to these large research projects which kind of quantify how many of its leading officials were somehow implicated in the Nazi project. And we have a wonderful graph which shows you at least some of that in quantitative terms. 54% of all of the leading officials in this ministry between 1949 and 1970 have been members of the NSDAP, the Nazi party, while around 27% had been members of the SA and 6% had been members of the SS. I have to say, this is from 1949 to 1970. The stuff that I'm going to be talking about in the rest of this presentation mostly happens from 1950 to 1960. The percentages there are even higher. Now, reconstructing what the stance of the Federal Ministry of the Interior was in relation to these Jewish German citizenship law issues is made difficult by a few things. One is the loss of key sets of files. So all of the files from the ministry, more or less all of the files from the ministry for the interpretation and application of Article 116, paragraph 2 of the Constitution for the years 1950 to 1976 have been lost or destroyed. They weren't always lost or destroyed. 14 volumes had been consulted in 1976, as we can see from this bibliography of a study published in that year. Those 14 volumes of material are gone. So this makes it a little bit harder for us to reconstruct what the ministry was thinking about this issue. This problem is also compounded by the ministry's loss of all of its files relating to discretionary naturalization for 1950 to 1960. Yeah, I'm going to jump in to just talk about what we can reconstruct on the basis of the documents that are there. And what were the actions of the individuals in the ministry who were responsible for making decisions in relating to citizenship law policy. So one of the people who's important in this regard is this man. What is this? Oh, we can just move this a bit. So that you can see Dr. Werner Füßlein, who served as the head of the Subdepartment for Public Law, which is this subdepartment that you see here before you on this organigram. Werner Füßlein had joined the NSDAP in 1933 and had gone on to be a member of several other Nazi organizations. If we look at documents from the Nazi period in which he was kind of assessed by his employers, we find often the judgment that he was a National Socialist of conviction. He was able to convince others of the validity of the National Socialist worldview. He was, however, in the post-war period, able to secure a categorization as unbelastet, so unburdened by an association with National Socialism, largely because his father had been a priest in the Protestant church, and he was able to mobilize a large number of priests as character witnesses who supported him in his claims of having always openly opposed National Socialism. So he's one important figure here, so far as he's in charge of the subdepartment in which citizenship law issues are dealt with. Another important figure is this woman, Anna Dlugosz, born 1903 in Oppeln, so in Silesia, in one of the territories which is lost to Poland after the Second World War. She joins the Department for Citizenship Law in 1950 and ends up becoming the head of that department in 1953. She's one of the only women to lead a department like this, a Referat, in a West German federal ministry in the 1950s, and definitely one of the only ones who leads such a Referat which has nothing to do with women's issues. Normally, women are placed in control of women's Referate in the federal ministries at this time. And there's another individual who's important for this story. That's a man for whom we have no photograph, a man called Fritz Samuel Fiegel, who was born in Berlin around the turn of the century and worked as a judge at Berlin courts until he was removed from his post due to his Jewish ancestry in 1933. In the same year, Fiegel fled to London and retrained as a barrister. And as you can see from this screen grab from Google Maps, and the little red arrows are his places of residence, he lived in areas which were not thin on, well, where German Jewish refugees were not thin on the ground. He is a product of Northwest London. He is a product of the German Jewish experience in Britain in the 1930s and in the 1940s. Until he returns to Germany as a member of the occupying forces in 1948. 4 years later, he's recruited to act as a Referent für allgemeine Wiedergutmachung, a director of the Department for General Wiedergutmachung in the Department for Staatsrecht, in the Department for Public Law. So this is really a very, very interesting position. Normally, Wiedergutmachung in these ministries at this time is understood mostly in the kind of frame of financial compensation. There is a department for Wiedergutmachung in this ministry at this time, which deals only with financial compensation for professional damages and setbacks suffered by civil servants. This role is very different. This role is related to the coordination of Wiedergutmachung understood in a very broad way across different policy areas. He's charged with the task of overlooking anything which could touch upon the question of Wiedergutmachung throughout the different parts of this ministry. And he is also the kind of entry point for Jewish complaints and Jewish demands relating to citizenship in the 1950s. In 1954, he's contacted by a Jewish welfare organization which draws his attention to some of the problems faced by German Jews in citizenship law, which I described to you before. So specifically, the fact that Jewish former German citizens who had acquired a foreign citizenship before being expatriated, that they're being denied the right to renaturalize. The treatment of the Jewish Germans from Danzig who are trying to enter the country and whose applications for permission to enter are being denied. Those are the problems which he's informed of. And he writes immediately to Ernest Lugosz, his colleague who is responsible for citizenship law issues, and asks her to take these issues into account, to address them in an upcoming bill that she's working on, which is going to deal with some open questions relating to citizenship law in the wake of the Second World War. And in his letter to his colleague, he makes an impassioned claim that this is an area where real Wiedergutmachung, real repair is possible, right? Citizenship as that form of legal practice in which the state recognizes belonging and membership in the polity, in the political community. The restoring this is somewhere when we can perform real Wiedergutmachung as opposed to mere compensation. What is the response which he receives from his colleagues to this claim? This is the only response that he receives, and I'm using receive very broadly. This is an annotation scribbled on the side of the page to the left of what you see here. The brown pencil that was used marks that this was a scribble by Werner Füßlein, his superior in the department. Why did Werner Füßlein have it? Anna Dlugosz, when she received this letter, did not respond to it herself, merely showed it to her boss, and then the two of them decided together to not respond to their colleague. And this was the path which they continued to take in the following months, when Fiegel sent renewed letters repeating his demand that the Jewish complaints be addressed, repeating his demand to be involved formally in the legislative process to represent those Jewish interests. All he receives is silence. And this only changes, sorry, that's okay. I'll speed up. This only changes several months later as the result of an intervention by Jeanette Wolf, a Jewish member of the Bundestag, a Holocaust survivor, an MP for the Social Democrats from Berlin, and up until this very day, the only Jewish woman who has been a member of the Parliament of the Federal Republic of Germany. The intervention which Jeanette Wolf brings is to put forward the Jewish demands, which Fiegel had received in February 1954, which he had shared with his colleagues several times in the following months. Jeanette Wolf puts forward those same demands in a committee of the Bundestag in which the bill that is being discussed, right, the bill that Fiegel wants these demands to be built into, she brings forward these demands in a session of one of the parliamentary committees where that bill is being discussed and kind of drafted. And that's the Expellee Committee. And the members of that committee passed a resolution demanding that the Federal Ministry of the Interior engage with those demands, that it produce provisions which would set those demands into law, and that those provisions can then later be kind of the subject of further parliamentary deliberation. How does the Federal Ministry of the Interior respond to this? So this is a letter which is sent by Werner Füßlein to other federal ministries after this intervention by the Jewish Holocaust survivor Jeanette Wolf in the Bundestag. He is inviting these representatives of other federal ministries together to discuss these demands and how they should respond to them. And it's very interesting to look at how the representatives of the other ministries kind of respond instinctively to the demands being put forward. So just to think about the Jewish former German citizens who had lost their citizenship through the ordinary provisions of the Nationality Act and were now being denied a right to renaturalization. This is the response of a man called Günther Bode, who is a representative of the ex-Berlin ministry. He says, for the existing restrictive interpretation of Article 116, paragraph 2, one can only rely on the word removal that is in the provision. But the authors of the basic law probably did not consider the consequences of this wording at the time. Yet the underlying idea for the Wiedergutmachung concerned not only the fact of denaturalization, but rather the persecution by the home state and the denial of state protection. The emigrants were factually already stateless before the citizenship was removed. Right? So this is, I think, also a kind of statement which shows us a few things. More of an attunement to the historical reality of the individuals who were affected by Nazi persecution, and also an understanding of Wiedergutmachung, its purpose, its definition, which goes beyond a simple focus upon one individual legal detriment, right? It's understanding the conditions under which these individuals acted. What was the broader context within which they acquired a foreign nationality? What does that mean for how the state should now look upon them and what legal rights are granted to them by the constitution of that new state? How do the representatives of the Federal Ministry of the Interior who are present at this meeting respond to this claim? So Werner Füßlein concedes the validity of Bode's fundamental claim, right? This is probably not an exclusion which was intended by the authors of the Basic Law, but he still says that he does not want to grant an absolute right to naturalization to these Jewish former German citizens. What reasons does he give for denying this extension of a naturalization right, which he himself concedes was likely intended by the authors of the Constitution? The answer he gives is, the only ones who will be interested in returning to Germany are those who have no financial basis for their existence abroad. The only ones who will be interested in returning to Germany are those who have faced and are facing difficulties abroad that they cannot master. His subordinate, his colleague, Anna Dlugosch, in charge of citizenship law affairs in the Federal Republic of Germany from 1953 until 1961, supports this claim and underlines persecution under National Socialism can be taken into account when dealing with ordinary discretionary naturalization, where our discretionary decision-making powers allow us to exclude undesirable applicants, meaning in this instance, impoverished Jews. What do they go on to discuss in the rest of this meeting? The rest of this meeting is dedicated to Füßlein and Dlugosch presenting to those present the special procedure that they have devised to aid the accelerated and cost-free naturalization of foreign Waffen-SS veterans living under false identities in the Federal Republic who desire speedy naturalization so they can be protected against extradition and prosecution by their former homelands. Dlugosch, in the preceding months, had met multiple times with the individuals representing the interests of Waffen-SS veterans and had written internal reports describing their situation as so urgent that she thought it was necessary to help them via the path of individual naturalization. Something which you kind of think, who would have written the script for this? I mean, it's a little bit too much, but it kind of continues along these lines. So the minutes that I was just kind of quoting from, this is what they look like in the files that we have. You see that they still bear corrections made by hand. Those are corrections made by hand by Dlugosch. In ordinary ministerial administrative work, this would be the first draft that would later be replaced by a typed version in which these handwritten corrections would have been implemented into the typed account. Why is this not included in the file? The reason for that is the Interior Ministry tried to erase this meeting from the historical record. This draft set of minutes that you see is not located in any of the many files documenting the drafting of the bill, the Gesetz zur Regelung von Fragen der Staatsangehörigkeit, but is rather located in another file dealing with another topic that was also touched upon in the same meeting. After this set of minutes in that file, we find a series of letters from another ministry, the Federal Ministry of Finance, which requests that the Federal Ministry of the Interior send over the minutes of the meeting from the 11th of May. And they send this request not once, not twice, not 3 times, but 4 times over a period of, well, September to March. I'm not very good with maths, but maybe someone here can put that together. Eventually, the Federal Ministry of the Interior responds in August 1955 to say a decision was made to produce no written account of this meeting. By the way, it also goes on to say, I told you about this on the telephone a while ago. So this is not just a minor detail, this is a very important one because it shows that the Federal Ministry of the Interior's officials are deviating from the prescribed norm that all communication in these affairs has to take place in the written word. And that written word has to be taken to the files. And it's telling that they are trying to move away from written communication and opt instead for oral communication when dealing with a topic as explosive as this. Now, what could be the reason that they decided to try and erase this meeting from the historical record? I think you can probably guess. I mean, having a written record of state officials saying the Constitution wants to go further in granting naturalization rights to victims of Nazi persecution, but we don't want to because we want to reserve the opportunity to deny the renaturalization of impoverished Jews, while going on to then lay out your special plan for helping to naturalize foreign fugitive Waffen-SS veteran criminals, doesn't go down that well. Especially if you have someone in your sub-department who is fighting to be involved in the legislative process relating to that bill, which Fiegel was continuing to do. And the conflict between Fiegel and Dlugosch is intensifying in the weeks immediately after this meeting of the 11th of May. And it reaches an apex when the two of them have to have a meeting with the highest ranking civil servant in the Federal Ministry of the Interior, a man called Hans-Ritter von Lex, where they're meant to kind of solve the differences about how the Jewish demands should be dealt with. Both of them come out of that meeting and write accounts of the outcome, which fundamentally diverge. Fiegel claims that the State Secretary Hans-Ritter von Lex had viewed all of the Jewish demands as legitimate. Dlugosch instead writes that he had said that all of them were to be rejected. Some of the reasons that she writes in her account are interesting. For example, she claims that Hans-Ritter von Lex rejected the idea that the Jewish ethnic Germans of Central and Eastern Europe had been excluded from mass naturalizations on racial grounds. He rejected the idea they should be granted a right to naturalization because these Jewish immigrants may have identified as Germans before their emigration, but they probably did not act like Germans. Also sie haben sich wohl nicht wie deutsche Volksangehörige geriert haben during their emigration and in the years after the collapse, Zusammenbruch, meaning the breakdown of the German state. Now, this conflict between the two, they try to find a resolution. Hans-Ritter von Lex is written to and he's asked, could you, tell us which one of the two accounts is correct? They seem quite different. He responds 3 weeks later to say, I don't know, I can't remember everything that happens in this building. And before he can kind of jog his memory, a rather tragic solution to this conflict produces itself when Fritz Fiegel suffers a stroke and dies the following day. After his death, his department his Referat is moved out of the Subdepartment for Public Law and is moved into the Department for Wiedergutmachung, into the department which deals merely with financial compensation for professional damages suffered as a result of Nazi persecution, and it is left unmanned for at least 1.5 years, 2 years. One of the consequences of this is all of Fiegel's own files have been lost or destroyed. There is no record of any of his own activity in the ministry, any of his own activity as the director of the Referat für allgemeine Wiedergutmachung. The only traces that remain of him are these letters to his colleague, the evidence of the ways in which he was sidelined, undermined, silenced, and excluded in his attempts to see Jewish demands actually respected and dealt with in the ministerial bureaucracy of the 1950s. After that death, the section that he had, the place that he had in the Department of Public Law, section 1B5, is transformed into Referat for Naturalizations. So a new department that will decide on discretionary naturalizations to kind of lessen the workload of Anna Dlugosch, who is now only going to be dealing with fundamental questions of citizenship law. What is one of the first decisions which we can find that came out of this referat? As I said, all of the discretionary naturalization files for the BME for 1950 to 1960 have been destroyed. The traces we find of their decision-making practices have to be found in other archives. And this is one decision which I found by chance in the archive of Nordrhein-Westfalen, and it relates to a naturalization application from a Polish-Jewish couple. They had lived in Germany from 1919 to 1935. When they fled to Belgium, they survived the Second World War by going into hiding, taking on false identities as Aryans, but returned to Germany in 1951, living in Aachen and applying there for naturalization shortly thereafter. Their application had very, very strong support from the Interior Ministry of North Rhine-Westphalia, but it ran into some problems when it got to the Federal Ministry of the Interior. So this is the response of the Federal Ministry of the Interior in August 1954, so shortly after Fiegel's death and the establishment of the new Referat. The fact that L, the applicant, never tried to acquire German citizenship before the 30th of January 1933 is evidence that he never developed any profound bonds with his guest country. His current residence in Aachen does not seem in any way to be motivated by his relations with the German state, but rather only by commercial considerations. In all, there is no indication that a naturalization should take place in the future either. So this is kind of evidence, I think, of a broadly held mentality in this entire subdepartment at this key moment in history where this legislative work is being done. But there's more. In the next page of this file, we find a handwritten note from the official in the Interior Ministry of Northern Westphalia, noting that the official who had written this application, this rejection, had phoned them up to let them know a series of further reasons for the rejection, which should, well, I'll read outside. In relation to this case, Ministerialrat Shah contacted me by telephone and told us that he could not approve the naturalization. He voiced some reasons that were not included in the BME's letter and that should not be communicated externally. So once again, a very, very interesting and telling deviation from the primacy of written communication, opting for oral communication, and a very, very interesting example of the, when German you could call it Verschriftlichung des Mündlichen, right? Like the bringing down to writing of what is said orally. Okay, so just to quickly take stock, what kind of understanding of Jews' relationship with Germany speaks through the statements of the state officials working in this department of the Federal Ministry of the Interior? First, the idea that Jews might possess some kind of authentic, deeply felt, sentimental bond with the country of their birth, of their childhood, of their adult life. This is an idea which is categorically kind of nipped in the bud before it even emerges. It's never even entertained by these officials. They also cast fundamental doubt upon the veracity or authenticity of these individuals' Germanness, right? So Dlugosch's statement that the Jewish ethnic Germans of places like Danzig, of places like Prague, of places like Czernowitz, didn't act like Germans when they had managed to escape what otherwise would have likely been a certain death. And finally, any interest which these individuals show in having a kind of connection with contemporary Germany is instinctively and automatically passed and interpreted as being motivated by financial self-interest or other kinds of commercial considerations. So this is a very unreconstructed anti-Semitism, which is determining their entire understanding of German Jews' relationship with a country that might have been their former homeland, their former state, their former place of residence, or the kind of center point of their cultural nation. So just to say that, what happens in the legislative process following Fiegel's death? I'm going to speed up a little bit with this one. So after Fiegel's gone, there's no one representing Jewish interests in the BME as part of the legislative process, so that Dlugosch is able, in the next step, to convince the parliamentary committees that the Jewish former German citizens who'd lost their nationality through the ordinary provisions of the Nationality Act, they don't need a right to naturalization. Discretionary provisions will suffice. So we don't have to include something for them there. The parliamentary committee goes along with it and decides they don't need to include a right to naturalization in the bill. She also manages to convince, sorry, I'm going to move this up to the top where it hopefully won't be so annoying. She also manages to convince the members of the committee that the right to naturalization for Jewish ethnic Germans who've been excluded from the mass naturalizations on racial grounds, we need to subject that to a few more restrictions. We need to say that this right will only be granted if these individuals have not acquired any foreign citizenships in the intervening time. So just to be clear, for someone from Czechoslovakia, this would mean they would have to be stateless for 17 years. And they also need to be living as a permanent resident in Germany at the time that this law comes into force. What does that mean in practice? I had another example. This man, Edek Czarniskowicz, I'm probably pronouncing that wrong, a man who'd been born in the kind of Silesian border region in 1925. He grew up speaking German, Yiddish, and Polish. He also lived through various ghettos and concentration camps during the Second World War, survived them, and found himself on German state territory in 1945. He remained in Germany for 4 years before migrating to Israel in 1949, until he decided to return to Germany in 1957. So he's an individual who would have been automatically made into a German citizen during the Second World War if he hadn't been Jewish. He decides to return. Sorry. Apologies for the language. He returns to Germany in 1957 to pursue his compensation claims, initially on a tourist visa, but once he gets to Germany, he applies for permanent residency, or at least a kind of long-term residency permit that would allow him to work. This application is denied by the local authority in Munich less than 4 months after he's arrived in the country, and they issue instead an Aufenthaltsverbot, a ban on residence. He ignores this Aufenthaltsverbot until he's arrested in Hanover in May 1958, and he is then taken back to Munich, where he is imprisoned as punishment for overstaying his residency permit, at first for 2 months, and then he is held in custody until he is deported to Israel a year later. While he's in prison, he applies for formal recognition as an ethnic German, and this is granted, but only after he's already arrived back in Israel, or after he's been already deported. Once he's there, he files a legal appeal, demanding kind of recognition as a German citizen through various provisions, and he's told Section 11, so the new provision which has been created for Jewish ethnic Germans, cannot be applied to you because you were not living permanently in Germany when this law came into force in February 1955. There is the possibility of discretionary naturalization for ethnic Germans from Eastern Europe who are living abroad, but that too is denied because he had demonstrated by overstaying his residency permit that he was an individual who did not respect German residency law and as such was not worthy of discretionary naturalization. So what happens in the rest of the legislative process? I told you that Dlugosch was convince them that Jewish former German citizens don't need a right to naturalization. In the next stage of the legislative process, during the reading of the bill in Parliament, the SPD brings in an amendment which will re-establish a right to naturalization for these individuals. This is part of a silent exchange between the Social Democrats and the Christian Democrats. So the Social Democrats bring forward their amendment, which establishes the right to naturalization for Jewish former German citizens. And this is kind of bought, the support of the CDU, the Christian Democrats, is bought by the SPD, agreeing not to oppose the CDU's attempt to create a right to naturalization for ethnic German Waffen-SS veterans on the basis of their Waffen-SS service. So the right to naturalization for Jewish former German citizens has to be bought in 1954 through acquiescence to granting a right to naturalization on the basis of Waffen-SS service, including to individuals who had served as guards in concentration camps, put forward by the Christian Democrats, so they can enjoy their pension rights abroad. In the next stage of the parliamentary process, one of the states puts forward an amendment asking that a time limit be imposed on the right to naturalization for the Jewish former German citizens, and only for them. No other naturalization rights in this bill should be subject to a time limit at all. It also turns out this move by Rhineland-Pfalz had been demanded by Anna Dlugosch in a phone call to the ministry. Again, the evidence of this phone call is only found in the archival holdings of other ministries. This phone call, according to the archival documents of the Federal Ministry of the Interior, never took place. So again, evidence of the use of oral communication as a way of trying to kind of undercut these Jewish demands. What happens in the next step? I think we can skip over this bit. So What do we have then after 1955 when this new bill has been created? A time-limited naturalization right for Jewish former citizens ends at the end of 1956, and a naturalization right for Jewish ethnic Germans, which is so restricted that almost nobody can use it. Towards the end of 1956, the same Jewish organization which had put forward the first demands contacts the Federal Ministry of the Interior again and says, a few things aren't working here. Could you make a few changes? Essentially make the right to naturalization for Jewish ethnic Germans usable by removing the strange restrictions, remove the time limit which existed for the Jewish former German citizens, and also grant a naturalization right to their descendants, thereby bringing it into line with Article 116, paragraph 2, which included descendants in its granting of rights. The response of the Federal Ministry of the Interior is interesting. So first, Dlugosch writes in response, no, this isn't necessary because no one's really interested in these provisions. There have been so few applications for naturalization through Section 11 and Section 12 that I think the number of people who'd be interested in the changes you're asking for is too small to justify changing the law. This is the response of the Federal Ministry of the Interior to the Jewish organization. Now, in their internal assessment of the Jewish demand, there's something slightly different being said. Namely, the number of applicants through Section 11 might be this low because the provision requires that individuals must have been permanent residents in Germany at the time that the law came into force, and hardly any grants of permission to enter and move to the country would have been granted before that time. So really, here we see the kind of perfidious argumentation of the Federal Ministry of the Interior, an internal documentation accepting that the low numbers are the result of the restrictive way in which they had purposely formulated that provision to make it unusable, and then in public responses to Jewish organizations, citing those very same low numbers as evidence that there's so little interest in this provision that there's no need to actually legally extend it. A further request which this Jewish organization made, which I forgot to mention, was the establishment of a right to naturalization for those Jewish residents of Germany who'd lived there before 1933, who did not have German citizenship, who'd been stateless or had been foreign. Remember, 40,000 individuals were born in Germany and living in Germany in 1933 who did not have German citizenship. And the Interior Ministry responds straight away that this is completely out of the realm of possibilities. You know, these individuals had never been German citizens, and we can't grant them kind of a Wiedergutmachungsrecht simply on the basis that they might have become Germans at some point in the future. So the Jewish organization changes their demand, and they say, well, could we at least say that these people should be given a right to a residency permit? This is answered by the Interior Ministry in this way. These individuals did not have a right to permanent residency when they left the former Reich territory. Granting them a legal right to permanent residency would give them rights that they did not possess before they left Germany. Such an improvement of their standing goes far beyond the idea that underlines Wiedergutmachung. So once again, a very different understanding of Wiedergutmachung here than that which had been kind of put forward by some other actors in this ministerial kind of battle in the 1950s. Sadly, this is the understanding of Wiedergutmachung which ends up being dominant in relation to questions of citizenship and residency law in the 1950s. Once the Federal Ministry of the Interior rejects all these demands this way, the Jewish organization says, okay, we're going to bystep you, we're going to go straight to the members of parliament, and we're going to focus on the one thing we think we can get, which is removing the time limit for the renaturalization of former German Jewish citizens and asking that this right also be granted to their descendants. And the members of parliament respond a lot more positively to this than the Federal Ministry of the Interior does. When this happens, alarm bells ring in the Federal Ministry of the Interior, especially at the idea that the descendants of these individuals should be granted a right to naturalization, which is not bound by any time limit at all. These two demands taken together would mean Wiedergutmachung for eternity. A right to naturalization for children and children's children without a temporal limit. Now, one could, I'm giving you a very dramatic reading, but I think this also aligns with the millenarian prospects being sketched out by this state official. One could describe it in much more sober terms. One could describe this as merely an equalization of this provision with its constitutional pendant, with Article 116, paragraph 2 of the Basic Law, which grants a temporally unlimited right to naturalization to victims of Nazi persecution and their descendants. why would the constitutional ministry of the federal government, right? The BME is also responsible, I forgot to say that earlier, for overseeing all government activity and making sure it is in line with the constitution. Why would the constitutional ministry of the federal government have such an issue with equalizing provision with the existing constitutional pendant? To answer that question, it's useful to know that the government or the Federal Ministry of the Interior had already for 2 years been looking for ways to introduce a time limit to the constitutional article itself, tasking an expert commission of individuals working on citizenship law questions with one of the 10 questions these experts were given was, can we introduce a time limit for the basic law itself? Can we say that after 10 years, maybe these individuals shouldn't have a right to renaturalization anymore? So that just gives you a kind of thinking that's going on here. The Federal Ministry of the Interior isn't able to bring through this limitation on the federal, on the basic law. They are, however, able, through the kind of use of intermediaries in the parliament, to at least introduce a time limit for the descendants of this group, right? So for the descendants who's lost their, individuals who lost their citizenship through the ordinary loss provisions prior to expatriation. For those individuals, their right to renaturalization is only going to exist until the end of 1970. After 1970, they no longer have a right to naturalization. Those descendants, the descendants through Article 1.6, paragraph 2, continue to enjoy that right. Okay, what's this? Right. So just to say what happens after 1960, this is the last example of an intervention by any Jewish organization that I've been able to find demanding an alteration of the legal situation relating to the citizenship rights of German Jews and their descendants. I have to qualify that by saying we do have the issue of all of the files of the Federal Ministry of the Interior from 1950 to 1976 relating to 1.6 paragraph 2 having been lost or destroyed. And also I've been denied access to any of the files of the Central Council of Jews in Germany. So I can't look in their own files for whether they did that. But this is something that I've generally seen. There's no contestation of this from Jewish organizations after this point in time until the late 2010s. We do, some good news, finally. We do see an improvement in the 1960s in terms of the Federal Ministry of the Interior's responses to discretionary naturalization applications from different Jewish individuals. The kind of really blatant anti-Semitism that we found in some of the examples I showed you before does not occur again after the 1960s. Oh God, we're really over. Essentially, okay, I'm going to jump forward a little bit. We're not going to talk about the gender of descendants, but I am going to say what happens then with this weird, like, you have to leave to go to your, yeah. Okay, sorry. What happens now with this kind of really strange differential apportioning of rights between 1.6 paragraph 2 cases and the descendants of those who lost their citizenship prior to being expatriated? Right, the Constitution, there's no time limit at all, but for the other group, their naturalization right disappeared after 1970. This ends up becoming a problem in the 1980s because the children of those individuals, the ones who had a naturalization right until 1970, start applying for naturalization. They start putting in legal appeals. These are mostly people from Israel. And most of them are concentrated in Berlin for reasons which I won't explain. By the late 1980s, by the late 1980s, the Berlin courts have started developing a line of kind of jurisprudence, a line of ruling, which tries to grant these individuals also a right to naturalization through the Constitution, and does this through two main arguments. One of those arguments relates to the idea that the Palestinian mandate citizenship, which the parents of these individuals acquired before being expatriated, was not a full citizenship, so its acquisition did not automatically lead to the loss of German citizenship. That's one argument. Another argument is German Jews who acquired a foreign citizenship in the context of Nazi persecution never did this voluntarily. They were acting in a historical context in which that acquisition was forced, coerced by external circumstances. And as such, it should not be seen as having automatically led to the loss of German nationality. What is the response of the Federal Ministry of the Interior in the late 1980s, the early 1990s, a period on which Joseph Cronin is an expert pointing towards him, a period in which the German state, the newly unified German state, is encouraging Jewish migration from the Soviet Union, former Soviet Union, to repopulate Germany's Jewish communities. What is the response which the Federal Ministry of the Interior brings at this moment? One cannot claim that acquisitions of foreign citizenships in the context of Nazi persecution were always coerced or forced. It is far more appropriate to assume that the conscious rejection or turning away from the persecuting state involved, in most cases, a voluntary turn towards the Palestinian state, a freiwillige Hinwendung, in which those individuals had to place all their hopes at the time. That's not all. The Federal Ministry of the Interior goes on to accuse the courts of trying to undermine the intentions of the legislator who had created differential rights for differential groups of descendants. For what reason? Wiedergutmachung in citizenship law was purposely constructed in the way that I've described to you in this presentation, in a way that addressed the individual groups in line with the intensity of their respective fates of persecution. This complex of regulations cannot be broken by extensive interpretation. This would undermine Section 12 of the Staatsangehörigkeitsregelungsgesetz, making it applicable in only a small number of cases for which such a legal regulation would not be necessary. Now, as I think is clear, the differential apportioning of naturalization rights with different timelines to different descendant groups was not the result of a studied examination of the differing intensities of persecution suffered by these various groups. It was the result of attempts by anti-Semitic former Nazis to try and minimize the possibilities of German Jewish return to the German state, premised on the assumption that German Jews would only ever want to return to their country to act as financial parasites, that they were never really Germans, that their Germanness was always to be questioned and in question. What the Federal Ministry of the Interior did here in 1990, and again 3 years later, in an identical response to a similar judgment from the Berlin Administrative Court, was to engage in an act of fantasy, creating a different justification for this discriminatory treatment than the one that the ministry would have been able itself to reconstruct if it had simply taken the time to look at the files which were either in its own possession or simply down the road in the Federal Archives in Koblenz. So I'm going to stop there. This has been going on for a really long time. Yeah, anyway, if anyone has any questions.
Thank you so much, Nick. Thank you, everyone.
Thanks for staying.
For bearing with us with those technical difficulties, but it was a fascinating, rich talk. We have less time for questions than we might have done, but I'm happy to take a few. Likewise on Zoom, if you have any, I think probably at this point you could pop them in the chat. That would be much appreciated. Yes, well, do you want to field them or shall I?
You.
Okay, I mean, your hand went up first.
Thank you for that. It was fascinating. Obviously, you can't cover everything. And I was wondering what the relationship was. I mean, was it an interdepartmental one within the state? Because the very public face of the German state post-war to its support for the state of Israel and its establishment, and financial and military and all right across the board, for moral and possibly political and strategic reasons. What was the relationship between that commitment and the anti-Semitism that you're teasing out of the files of the Interior Ministry?
Before you answer, for the people on Zoom, could you just quickly repeat the question? Not you.
Me. Yeah, shall I also stand up, actually, if the camera's still running? I think the question was, what is the relationship between the kind of anti-Semitism we're encountering in the Federal Interior Ministry and the Federal Republic's very Israel-friendly stance in other aspects of policy? Very interesting question. I'm not sure if I can answer it satisfactorily. I think most decisions relating to the support for Israel financially and also in foreign policy terms would have been made in other ministries, probably in the Federal Chancellery, in the Foreign Office, probably very interesting discussions of that in the Financial Ministry as well. I mean, I don't know if we can say that the support for Israel is evidence of a lack of anti-Semitism. I think there's already been quite a bit of historical research into the motivations for Konrad Adenauer in pursuing that close tie with Israel, a belief in the kind of grand power and influence of American Jewry and the necessity of having a strong relationship with Israel as a way of winning over the American Jews who control the American government. In his thinking, I'm not triple bracketing the things I'm saying here. Also, I think that there is a lot of resistance in the federal finance ministry, both to reparation payments to Israel and compensation payments in general in Germany. I don't know if I'm providing an answer to what you're saying. I guess one thing is the support for Israel doesn't really cancel out anti-Semitism at all. But to say specifically about how this relates to the Federal Ministry of the Interior, you do see the evocation of the idea that one has to maintain good relationships with Israel in the late 1950s emerging as a reason for denying naturalization applications of Israelis who've migrated to Germany. But I don't know whether that's something which they're kind of just citing as a reason which is meant to cover up other anti-Semitic ressentiments. I would actually say this moment of 1954, where we see kind of lots of these horrible things happening, I wasn't able to talk about it very much, but there's another thing which is going on in the same sub-department at the same time, which is in response to Israelis returning to Germany, who'd been displaced persons in Germany for a long time. They'd gone to Israel and they return around Christmas 1953. And that sets off a huge amount of anxiety in the Federal Ministry of the Interior, attempts to block Israeli entry to the Federal Republic. So the Federal Ministry of the Interior, the sub-department, institutes a new discriminatory visa apportioning regulation, which makes it more difficult for Israelis to get entry visas to the Federal Republic than any other nationality in the entire world from 53 till 63. There's actually anti-Israeli, anti-Jewish sentiment in that ministry at the same time. Yeah, sorry, that went off on a different. I don't know if that answers your question. Kind of, why not? Okay.
Yes, you had a question.
Thank you. Yes, thanks for that, Nicholas. Was there at any point before the Article 116 was being passed into legislation, was it at any point that anyone sort of challenged the BMI for essentially not adhering to the Constitution, since it was a constitutional right?
So the Constitution came into force before the Federal Ministry of the Interior existed. What would they have challenged them on? So they could have challenged them on this interpretation which said individuals who acquire foreign citizenship after 1949 no longer have the right through 116 paragraph 2, but they wouldn't have challenged the Federal Ministry of the Interior directly, because the Federal Ministry of the Interior was only making decisions of approval of rejection in relation to discretionary naturalizations. So Anspruchseinbürgerungen were decided upon rejection or acceptance by the lender. So if they had rejected, it would have been any legal appeal would have had to go through the state level and couldn't happen immediately on the level of the Federal Ministry of the Interior, even though they kind of coordinate and set policy in those areas. Does that answer the question?
Yeah.
I forgot to repeat the question. The question was whether anyone had challenged Article 116 paragraphs 2 interpretation and application in the Federal Ministry of the Interior.
Any questions on Zoom? Maybe it's just not been typed out yet.
Okay. We'll take another one from the room then.
Thank you so much. That was fascinating. My question is whether jus sanguinis and especially sort of Nazi thinking around folk and Volksgehörigkeit is sort of the subtext or is sort of in these answers that you've been studying in the ministerial letters?
So the question was whether ideas about jus sanguinis and understandings of kind of German identity as being grounded in blood is the subtext to much of these kinds of pieces of correspondence and decisions. First to answer that, I think I would know jus sanguinis, understood in a kind of formal legal sense, doesn't have the same kind of substantive understanding of blood that the National Socialists charged it with after 1933. So the Nationality Act, which had been enforced from 1913, did enshrine jus sanguinis as the sole principle through which German citizenship was acquired at birth. through descent from a German citizen. This did not extend to ethnic Germans, right? This wasn't a kind of understanding of German blood as something which is more than legal. I think that the Nazi understanding of Jews as never being really fully German, not necessarily in a blood sense, but in a kind of cultural sense where culture is understood as an expression of the innate qualities of the blood, that's definitely running through all of this. I mean, the fact that you have this instinctive denial of the possibility of Germanness for Jews is an unreconstructed, Nazi hangover. But I don't know if we can reduce it to questions of blood. I think there's been maybe an overemphasis on the significance of jus sanguinis beyond the legal sense for understanding legal regulations in the 50s and 60s. So thanks.
I think we might have to make this the last question.
Right, okay, just a quick one. Thank you very much. Fascinating. I don't know if this is in your area of expertise, but we've been talking about the Jews being deprived. There were other groups in Nazi Germany as well. Was the treatment different between these groups, or you mentioned here and there like specific references to Jewish sort of treatment?
Yes.
Yeah.
So which groups are you thinking of specifically?
Well, I think the law at the time applied for political.
Yes. Okay. Yeah. Yes. Yes. So I focused on the Jewish cases here also because the Jewish cases in the kind of Nazi expansive population policy end up having this significance. These provisions would have all applied also to victims of political persecution who had their citizenship removed or lost it. And actually, that's a very, very important problem for the Federal Ministry of the Interior. And one of the reasons why they try and resist extending the right of naturalization to former German citizens who lost their citizenship before it being removed, because they say social democrats went to other countries and they naturalized abroad. And there's Ortsgruppen. They have established new political parties abroad and they want to return with all of them in tow. That's a reason which they internally mention. At some point, they even try and put forward a formulation of what becomes Section 12, right? Where they say only racially persecuted individuals. They don't want any political persecutees. They don't want any religious persecutees. And this is, I mean, the Federal Ministry of the Interior is also rabidly anti-communist, rabidly anti-social democrat in this period. And that's something which I wasn't able to talk about here, but that's a really central aspect of their resistance to. Thanks for the question. Did I forget to state the question again?
I think I probably got it.
Okay, I'll answer it, yeah. Got it, yeah. Okay, it was the last one. Over to you.
Right, so I think those of you here in the room probably deserve a drink. We have got refreshments to turn left at the end of the hall. Thank you once again. Apologies once again. Thank you to those who joined on Zoom. We'll see you all again next time, hopefully. But in the meantime, please, once again, give a very big round of applause to Dr. Nicholas.
Yeah.